Good evening and hello. I bring you greetings from Omega Lambda Omega of Alpha Kappa Alpha Sorority Incorporated. My name is Felicia Lowry Herndon, and I'm the president of our outstanding chapter. We serve North Raleigh, Franklin County for the areas of Alpha Kappa Alpha. This is part 4 of our 4-part series. Please feel free to join us on Facebook and follow us on Instagram and check our website regularly for our programs. Welcome and thank you for attending.
Now that I'm unmuted. Good evening, everyone. My name is LaShara Owens, and I'm the co-chair of Building Your Economic Legacy. Again, welcome on behalf of our committee. This is the 4th and final session for our 4-part financial literacy series. Some virtual tips that we have for you tonight are all lines are muted. Please do not unmute unless you are speaking or asking a question. Please add all questions to the monitor chat in Zoom or on Facebook. Please participate in the poll questions that we have. Please add your email address to be contacted by the presenter for more information if you would like more information. And please position your cameras properly so that we may see you all. Again, welcome, and please ask as many questions as you like. Do not hesitate. Thank you.
Okay, good evening, everyone. Again, it is my pleasure to introduce my friend and one of the best attorneys I know, Keith Shackelford. I don't know if you're like me, but I have not been very diligent about planning my estate. And Keith is here tonight to share some of that with us. Some of the things that we need to know as we age. Keith is a graduate of Wake Forest University. That's where he got his undergrad as well as his Juris Doctorate. He is now, and has been for a while, a member of the firm Warren, Shackelford & Thomas in Wake Forest. He specializes in helping clients plan estates, administer probates, draft wills and trusts, as well as business purchases and startups for you entrepreneurs, and civil and criminal litigation. He is also a member of Kappa Alpha Psi fraternity, the Wake Forest alumni chapter, and he's on multiple boards because he's a great volunteer. So I can't wait to hear what you have to share with us tonight. Keith, it's your turn.
All right. Good evening. So I will kind of run through the list a little bit here that we've got of questions, but this will be kind of free flowing. So I'm open to questions, a lot of questions. I will probably answer as I go, just because I see them a lot. A lot of the same questions come up in my initial conferences with my clients, and we usually talk about a lot of things in the course of that. So feel free to kind of jump in, or if you have a question, let me know, and I'll try to do the best I can to answer it. So we'll kind of start with sort of the basics here of what is estate planning, and when I sit down with my clients, kind of the overview part. So the first thing we talk about, and the main thing we discuss, is going to be your will. And that's going to be addressing what happens to your property, your children, and your assets generally after you die. So when we tie it back into the financial literacy, what we're really talking about here is what happens to all that wealth once you've collected it and you depart. The other 3 things I normally talk about aren't really estate planning so much as advanced directives or planning for the unexpected. And so we also include in that package a durable power of attorney, a healthcare power of attorney, and a living will. And I'll talk about each of those after we kind of talk about the will, the wills first. So what most people don't understand is, or realize, is if you die unexpectedly and you don't have a will, depending upon your family situation, your property may not pass in the way you want it to pass. For example, if you're married, in particular, if it's a second marriage and you have children from the first marriage, and let's say you've amassed a great bit of that wealth with your current spouse, then, and you die unexpectedly without a will, then your spouse is actually sharing your property with your children, and that may not be your plan, and vice versa. So the will kind of addresses some of that. There are also scenarios where you may die and you don't have a will, but it goes exactly where it's supposed to go if you had written a will. So it really does boil down to where you want your property to go and how you want things handled after you die. Now, depending upon your stage in life, has a large impact on the reasons for drafting your will. If you have young children or minor children, then we need to draft that will as much to make sure that we've got your preferred guardian set up to take care of your children and to finish raising them for you. And we also want to make sure we've got someone set up to manage their property that they inherit from you. And so how we do that is in your will, first thing we'll do is very basic stuff. And that is, generally most people are leaving everything to their spouse. And then if their spouse has predeceased them or dies simultaneously, then we leave everything to our children. So if we have minor children, what we're looking at then is having it set up so that your property passes to them, but it gets held by a trustee for their benefit. That is as basic as a trust is literally holding property for the benefit of someone else. And the kind of trust we put in the will is very simple. Mine is about 1.5 pages, depending upon the print size and line spacing. It's not very long. It's very broad and allows the trustee to use those assets for your children in any way they see fit. And the idea here is to make sure that there's assets available to assist the guardian who is raising your children. Now, the trust we're talking about right now, just to be clear, is going to be very basic. It's going to be when children are minors. But we can also make a trust so that if you've got adult children, as many of us do now, and they are not very good with money, and we've got some of those, then we can also put their money in a different kind of trust sometimes to help control their ability to squander that. And in fact, when I draft that basic trust that I'd include in my will, our kids, meaning my clients' kids, don't actually receive those assets until they hit the age of 25. Most of us remember our 18 to 22 time frame when we were adults and able to have access to money, and we weren't always the best with that. So we normally set ours at 25, and then we adjust it according to our clients' needs. Let me see here. I feel like I'm missing some questions. And I can't figure out how to work this thing here. Hang on 1 second.
Keith, I just asked, if people had a will, and most of the audience does not. But one of the questions that is in the chat is there an age limit on a trust?
So no, there's not. So what we're talking about right now is a will, okay? But there's a lot of people will come into my office and say, oh, I talked to my financial planner and they said I need a revocable trust or a living trust. And so when we talk about those kinds of trusts where it's freestanding from the will, there are scenarios where we will have money held or have property held for the benefit of someone else. It doesn't have to be your child, but age does not matter. One of the things I usually go through with my clients, and I've got one right now that I'm working on drafting a trust. And the question becomes, well, if you've got an adult child, and in this scenario that I'm dealing with currently, there is a potential judgment that's going to exceed auto insurance benefits or limits, excuse me. And so they're trying to make sure that if they die, that the plaintiffs in that lawsuit aren't able to access their child's assets. So, and that child's probably in her it's got to be in her 40s based off the age of my client. But in that scenario, it's not a problem with the age. The question becomes, at what point does she receive those assets free and clear, if ever? And so you just have to address those kinds of things, but there's no age limit on that. And to kind of address a little bit on that trust, which does come up often, and I'm sure many of you have heard that, a trust is an effective tool. I typically advise against using a trust unless we have a reason in addition to trying to avoid probate. Probate administration is not a bad word in my office. It's part of what we do. And frankly, in North Carolina, we don't have to deal with inheritance tax or anything like that. And even the fees you pay on it are basically capped out at $6,000. And so when I do the rundown of going through assets with my clients and we kind of start having this conversation, most people have their assets in their house. And then that's usually the largest asset. And then after that, it's investments. And typically with your investments, you are going to have those payable on death to someone else. And so that means basically you've got your house and then your assets they're passing outside of probate. Anyway, it really just doesn't pay or make sense to have a trust sometimes because it's just unnecessary. I can sell you that trust and I can make a little extra money. I've had people come in, and I don't know if y'all received this advertisement, but you'll see where these firms or companies will have these large settings where they'll have a seminar and they'll sell you this beautiful package. It's got a beautiful notebook. You get your trust, you get your will, you get all these things for $6,000, and it's just unnecessary. You don't have to pay that kind of money to have an effective estate plan. And so typically we don't do a trust unless we have other reasons for doing it, like we are trying to protect an adult child from squandering their inheritance or something along those lines, or we want to make sure our second spouse has access to the house for as long as they want to, and those kinds of things, and we provide for them in those ways. So it's usually when we're going to do something a little bit special when we want to use that trust beyond just for a minor. So, but your will, for most people, the will is very simple. We call it a simple will. As complicated as it can get, it's usually just adding a guardianship and a trustee trust to the will to take care of the minors. You can take that will and make gifts to your favorite charity. You can leave things to particular people if you want to, all those sorts of things. And so you've heard me kind of harping on a little bit on how we're going to use the will to plan if you've got children, minor children, but also if you're single. If you're, well, I married late in life, was 47. And so for me, until then, it was, I don't have kids. I don't want my dad to inherit from me just because of our relationship. My mother died long ago. So the question was, where does my property go? And so for me, it was different. It was that will was making sure that I was able to take care of my siblings in the way I wanted to. I got, 5. And so for me, it was a particular sibling. I wanted to make sure she was amply taken care of what I had. So it just depends on what your situation is, on the importance of that will. It's important, but it's important for different reasons for different people. So, but that's the basics. Literally, my initial conference usually talking about wills, it can be very short sometimes. And so are there any questions about the wills themselves? And I'll talk a little bit about probate since we're talking about that.
There's another question in the chat from Santina. After someone dies with a will, who administers the will? Is it an identified family member or an attorney?
Great question. So in your will, we're going to name an executor, okay? And most people are going to go with their spouse, but we'll typically name an executor and an alternate executor. In our wills, we just refer to them in the general term of personal representative. Perfect segue into what that person does then. So when you die, in order to what we call probate administration, what that is really it's opening a legal entity, if you will, like a corporation that now represents your person after you're gone. So instead of it being you, now it's this entity called your estate. And the executor, you could compare it to like the CEO of that company. And so this, as the executor, that person is the one, once they are appointed and installed into office, if you will, then they have the authority to act on behalf of the estate. Okay. And so part of what they do and part of their main responsibilities, how I normally describe it is, first thing is collect the inventory. You have to basically collect and gather everything that the estate owns. A lot of times I'll have people come in and they want to go pay mama's bills and do all these things. Say, whoa, slow down. You have to do this in a certain order. And so the first thing, and I'm set up that I can see some of the questions now too. So, but the executor then kind of collects the property, and then they also have to run an ad letting creditors know that the estate is open, and that if they want to get paid, they have to file a claim against the estate. And so that period lasts about 90 days. And at the same time, we're kind of, contacting the banks, identifying how property was owned and making sure that it's estate property versus property that passes directly to a beneficiary or some other form like that, or maybe jointly owned. And so once we've identified all of that, at that point, we get past that 90-day mark, and then we can start saying, okay, who gets paid from this estate and who has priority? And so it's the executor's responsibility to then follow the statutes and follow the law and make sure that we take care of certain things first. And so, one of the benefits in doing it this way is if you're married and your spouse has a ton of debt, and then they die mysteriously, wink, wink, what happens at that point, if we go through and start paying, the funeral expenses first, last medical bills, and then we get down to those credit cards and all that bad debt, those things simply won't get paid. And it doesn't attach to you as a surviving spouse, so it gets wiped out. So that kind of is done. Things like your real property, that your house you own with your spouse, is going to naturally pass to your surviving spouse. We don't have to do much there. So it's kind of dealing with those sorts of things. At some point, though, if we have a house, let's say we're not married or the first spouse has already died, and we get to that point where we're paying creditors' claims and there's not enough money to cover those claims, then we start looking at property like the house to satisfy the estate claims. Otherwise, the house does not play into your probate administration at all. Now, one of the questions here, and it's a good one to kind of go back to this trust and the pros and cons of a living trust. I saw that, and I think this is a good segue. So if we have a trust and you've died, most trusts are going to have language that says, take care of anything, all creditors' expenses, medical expenses, last expenses. You, as trustee, must take care of those things before you distribute to the beneficiaries. The exact same thing that we have to do in probate administration. And that's why I say it's not a bad word, is because you're basically going to do the same thing one way or the other. Now, you don't have the oversight with the trust that you're going to have with probate administration when it comes to those kinds of things. So I think it's important to make that distinction. But the other part of it, one good thing about a trust, again, part of my thing is having a reason in addition to avoiding probate, but is to avoid probate. If you have a trust and you put all your property in that trust, I mean, your checking, savings accounts, ideally it would be your motor vehicle, although I advise against that, your motor vehicles. If you put all your property in that trust, then what happens is your trustee or your alternate trustee can step right in, not open an estate at all, and have instant access to your property, and you'll be able to take care of things. So it can be helpful. But it's to me, it's a lot of people in North Carolina, you don't get a whole bunch of benefit out of it because you're essentially doing the same work. And so it's really not, it doesn't necessarily justify the extra expense of having it. But if a lot of other states, it's beneficial because we avoid personal inheritance tax and things like that. Like I get a lot of trust coming in from clients that moved to North Carolina from Florida, Michigan, Pennsylvania is another big one. They come down in New York, where people will come and they'll have a trust And we kind of start talking about like, well, why do you have this trust? What was the purpose in it? Have you put any property in it yet? Well, if we're going to keep it, let's put as much into it as we can. Let's put your house in there. Let's put your checking, your savings accounts in it. Let's, if you've got minor children and you've got accounts that are going to be payable on death to them, basically, let's make the trust the beneficiary on that and kind of you want to drive all your property into that trust. Otherwise, you're not getting the benefit out of it. Because I've had a lot of people come in, they've got a trust and it's great, but they don't really have any property in it. And then they die and we still have to open an estate to take care of the car or to take care of that one account that, they just didn't put in the trust. It's not payable to the trust, but it's got $50,000 in it, let's say. We still got to open an estate and do all those things. So it really just comes down to, if we're going to use a trust, then my thing is, if we're going to use it, let's use it. Let's put all the property in there we can. If you own your house outright, especially, let's move it on in there. Let's talk about how we're going to really take full advantage of it, because it just doesn't make any sense to have one if you're not going to really take advantage of it. Now I'm going to scroll through a little bit. Now I can see some of these questions. We got some good ones. We talked about the executor. All right, so there's a good one on the mortgages. We're talking about probate. So a mortgage is going to be secured property on your house. So your house secures that mortgage. And so when you die, that mortgage is still attached to your house. So even if it passes to your children or to someone else, they're taking that house subject to the mortgage. And one of the first questions I have or conversations we have when it comes to that house is, do you plan to keep the house or do you plan to sell it? What's the goal here? What's the end goal here? And if people are like, yeah, we're going to sell it, and I say, look, don't pay the mortgage. It's not your contractual claim, or it's not your contract, so it's not going to go against your credit. Let it start moving towards foreclosure, but let's go ahead and put a for sale sign in the front yard and let's get it sold. Because essentially, once it sells, obviously you're gonna pay off the mortgage, all that gets worked out, and you're not coming out of your pocket to take care of that new bill you've got. So with the house, it usually balances out like that. Now, if you're going to keep the house, a lot of times what we'll do is we'll do the minimum depending upon the circumstances. Sometimes it's just a matter of putting the will and the death certificate on record. That changes ownership pretty much right then. And all you got to do is keep the mortgage up. So sometimes I've had some adult children inherit from their parent. They might not be able to qualify for that loan themselves, but all of a sudden they've got the house subject to the mortgage, but they can afford the mortgage. And so all they got to do is keep the mortgage up. Mortgage company has no problems with that. And then I see a next of kin contested will if they're not included in it. The answer to that question is yes. And what I have seen in the last 2 years is there are a lot of people that contest wills. So when we write a will, typically that excludes someone or a child from it, if we got older clients and we've got 3 kids and they're going to only leave it to one child, a lot of times what we'll do is we'll put some very specific language in there that basically says, it is my intent to leave nothing to Johnny. And it's very blunt. And I usually kind of make sure my clients understand that the language is going to be somewhat blunt, but we want to make it crystal clear that it's your intention to leave them nothing. In the last couple of years, what I've seen is, which is kind of funny how these things go, is I've had a brother contest a will based on the husband and wife being separated at the time of death. In fact, I've seen that twice in the last year. Even though the brother hadn't visited the family in 20 years in North Carolina, he was contesting the will, and it ended up getting kind of expensive. So you'd be surprised what we see. And in fact, you saw litigation in my biography, and it's funny how I have toned down or stepped back from litigation a little bit, but I'm doing more estate litigation as it comes up. So it can definitely happen. It can be expensive, and a lot of times it ends up getting settled. And so sometimes, even on a bad claim or challenge to a will, that person will get a little piece of the pie just to make it go away. And there's another goal. So on the will, so there's a good question here. North Carolina, in order for it to be a valid will, you can do a will a couple of different ways. The basic rule though is for it to be self-proving is it has to be signed and signed before 2 witnesses and notarized. And that's when we have a type will or something like that. You can also handwrite your will. If you handwrite your will completely in your handwriting and sign it, it can be a valid will. I believe it has to still be notarized or witnessed, but at the very least, it's a good argument that that is a holographic will, but it must be written in your own handwriting and signed by you. Or it can be written by someone else in your presence and at your direction and signed by you. So you'd be surprised at the different types of wills that can actually get through, but those are usually the cases where we're going to get into some litigation, because typically somebody has been written out who did not want to be written out, and they're going to challenge that will. Let's see.
So that was in response to the question about if you handwrite it, right? I saw that on a piece of paper, I think it was. I'm looking for it.
I saw it up earlier. To add on to that too, with a handwritten will. So a lot of times people move from state to state, and I'm actually surprised at the number of people that actually move to North Carolina from New York. My practice area is primarily Wake Forest, and so there are a lot of people that move in from New York and Pennsylvania, some other northern states, and Florida including as well. And a lot of times the question is, do I have to change my will because now I'm in North Carolina? And the truth of that is, from my standpoint, yes, absolutely. Come on in here, let me write you a new will, easy money. But the reality of it is, if that will that you drafted in another state either meets the state requirements, so it meets New York requirements when it was written, or meets their requirements at the time of your death, or if it meets North Carolina requirements at the time of your death, and that's going to be a valid will here in North Carolina and can be probated, period. We just got to take a little bit of an extra step when we go to probate it, but other than that, I've done it with as simple as attaching a copy of the relevant statute from New York or Florida, whichever the case may be. So, yeah, another question, Shima? I'm sorry.
There are a couple of questions I want to make sure we touch on. You touched on the mortgage question and the contest from the next of kin, and the will on the paper.
Holographic, yeah.
Pros and cons of a living trust. I think you've touched on that as well.
Yeah, that one's tough. And that's why I say I think it just depends on the scenario and what you're trying to do. Again, that is, if we're absolutely trying to avoid probate at all costs, then the trust is a way to do that. If you're trying to, again, protect your assets in a way, or if you're trying to, here's another good way to look at that trust. If you're trying to control your assets after you've died, then we do that in a trust. That's where you can kind of say, so-and-so doesn't get this money to age 30. They get, 50% at 30, another 20% at 35, and the balance at 45, or however the case may be. That's where a trust can be really useful when you need to do things like that. I see a question is, if they do not have a will but need a trust.
That's where I was going next.
If you've got, in fact, I'm doing something kind of like that right now, where I've got, this is probably a good example. I've got a client who's got a daughter. He is not on her birth certificate. She's got twins. I believe either the father is deceased or is just not involved at all. And so and he's setting up a trust because he's trying to take care of his fiance and take care of his daughter. But the interesting thing here is this, is one, if he dies without a will, she's not going to inherit from him. And she is his daughter in every way. She would not inherit from him. And if she dies, he's potentially going to have, he will have some issues with taking guardianship of her children because he's not on her birth certificate as her father. So it can be very tricky on that stuff. And I've seen that birth certificate issue come up a couple of times here recently, where if it's obviously with the dad, but if the father is not listed on the birth certificate and has never been ordered to pay child support or has not put that person in his will as his child, that child is not inherited. I don't know if y'all are familiar with Dunn Road up here off of Falls and Noose Road. I had a client in Wake Forest. His daddy, he was born out of wedlock in the 40s, probably in the 40s, and went around grandma, ran around dad on family property over there on Dunn Road. And unfortunately, his dad died and he didn't inherit. And there was nothing he could do because his dad wasn't on the birth certificate. And so if you know that area, that's now where Bedford Falls is, that property around there is pretty valuable. So it's just those easy things. So it's important for those reasons as well. And that's where, getting back to the question, having that will can kind of help make sure we're taking care of those kinds of issues, because they are issues. And so with this particular client, we are doing a trust. And in fact, we met last week and that was exactly the scenario. It was, hey, we just need to get something in place to make sure you and your daughter are protected in the event something happens before we get this trust drafted. And it's going to be very simple. Of I leave everything to my fiance and my daughter, period. No big fluff. And then we'll clean it up once we get the trust done. But absolutely, if you're going to do that, then we absolutely need to do that. And then go ahead.
Well, is that the same case for this question from Jasmine Grayson that says, if you and your spouse die and you have a minor child from a previous relationship, what's the best method to ensure your child gets the estate and not the previous spouse?
Good question.
Trust as well? Good
question. So yeah, that's where that trust comes in handy. So remember, we talked about the guardianship in your will and the trust in your will. So in this scenario, the surviving parent would have priority over custody, unless there's some issues in there and we find ourselves in a court battle over custody. But let's assume the father in this scenario, we'll assume this female spouse or female or mother, that minor child is probably going to go live with the father. But with the trust, what you do in your trust is the property they inherit from you, you have someone else as a trustee who you've selected, and you might even go ahead and name an alternate trustee. And when your child inherits from you, their property is going into the hands of that trustee to hold for their benefit. And again, the way we draft that trust is it's pretty broad, and we give the trustee complete discretion. So if the custodial parent now needs money, trustee does not have to pay it over. They can jump up and down. We might find ourselves in court. I haven't seen that happen yet. It wouldn't surprise me in this day and age, but the trustee would have full discretion to say no, and to hold that money until that child hits the age of, whatever age we've set, 18, 21, 25, when they would get those assets. So absolutely. That's how we work around that. And those are situations. A blended family is another situation where a trust can be a good tool to use, especially if we kind of, we got a house with a spouse and we're trying to kind of protect, it may be a situation where you want your child to be able to access the house you got before you got married, things like that. So in those situations, a trust can be very helpful because you can kind of get into a little bit more on controlling how that property is held and what it's done with. You can pretty much draft or put in whatever your wishes are in your will and your trust. I mean, if you want it in there, we can pretty much put it in there. Now we're going to talk about the effects and the ripple effects of those things, because sometimes they have some other impacts. But for the most part, if you got an idea and it's what you want, we'll kind of think it through, talk it through, and discuss the scenarios as best we can. And if it makes sense, we'll put it in there. Trying not to get too crazy.
So there are a couple more questions before we go to the next slide and get into the specifics. One is, what happens if you own land, which is in your name, but you've been separated from your husband for many years, never got a divorce? Can you leave the property that is in your name to your children and bypass your husband? Or is it going to go to him because you're not divorced, you're just separated?
So another good question. First off, get the divorce. That saves a lot of problems. But so with that, there's actually a statute that says if a spouse has abandoned you, if y'all have separated, and I think it's a divorce from bed and board, where basically you're living separately, you are, living in adultery, those kinds of things, that will actually disinherit a spouse. There are certain acts that bar spouse inheriting, and so divorce is an absolute one. And then other things along those lines. And so that statute, what I mentioned earlier, the two situations I've had in the last year and a half about spouse's ability to inherit, we've had to pull that statute out and look at it real closely. And so that is one that would probably save you in that scenario. But the best thing you can do, if you write that will and you leave that property to someone other than the husband, chances are it's going where you want it to go. But to be sure, that divorce is probably the best thing you can do. And the other part of it is settlement agreements typically will have a clause that says, you can't inherit from me, anything I got you on beneficiary on, you no longer the beneficiary on. And so that's part of the agreement. So we can always make arguments based off the separation agreement. I lost my train of thought. Something else I was going to mention on that. But yeah, so there are things like that that are built. There are a lot of things where the law actually steps in if we don't put it in a will, or if we don't have law will fill in the blanks on a great many things. So
there are two more questions. If you're married, and I think you covered this with that trust, if you're married with adult children and grandchildren, can you split your estate between them instead of it going directly to your spouse?
So you can. Now that doesn't, so, and this is where, so a lot of you got to remember, a lot of these things were written into law when men and women were not treated equally. So we'll see men assert these things now as well, but there are certain statutes that will allow a spouse to claim what we call an elective share. So if I'm married now, if I had a will and I did not include my wife in my will, and then I died, we go to probate, she could file for elective share. And what that's going to do is it's going to allow her to make an argument that she's entitled to receive a certain, I think it's about 50% actually, of my property. It kind of varies. It may be, I think it's 40% personal property, and the remaining 60% gets divided amongst children, and then 50% of personal property, something along those lines. And so your surviving spouse could still inherit from you by filing this elective share. It's a process. It's a little bit litigation, but you can, if you disinherit your spouse, if your spouse disinherits you, there are some things that are in place that will protect you. One thing we should also talk about as far as probate that comes in handy sometimes is year's allowance. So in North Carolina, a surviving spouse can also claim the first $60,000 in personal property. And so that's going to include cars, the checking account, the savings accounts. If there's anything that is beneficiary designated where he or she did not name a beneficiary, that surviving spouse can basically get that first $60,000. So when you look at this, leaving a spouse out of a will, that's one of the things that we get around it. Sometimes we'll file a spousal allowance, we get $60,000 there. And then we also go through the elective share, and we can get a good portion of the estate from that way as well and get around it. Now, that's why it's so important that when we do these wills, if you are if you're not leaving your spouse a portion of your estate, it's probably a good idea to have some kind of prenuptial or postnuptial agreement in place where they contract away those rights to inherit. Would be a good idea to make sure that we don't, if that's your intention, if that's the agreement, then that's something you want to do. Now, I'll add, going back to that trust, if you keep your property separate enough that you can draft a trust and put your property, your individual property all into that trust so that your trust owns your property, and then you die, that trust then becomes a irrevocable trust, and your spouse cannot make a claim to that. So there are some tools. That's why I say you kind of get into it and you figure out what the objective is, and then you determine what the best instrument is to accomplish those goals. And so if that's the kind of thing we're trying to do, that's when a trust can be very, very effective. And there's a very clear reason for using it at that point. So very good question. I hadn't thought about that. Let's see.
I have a question from Facebook. I'm not sure if it's gonna fit in this part, but it may. The question is, can you leave a sole proprietorship in a will?
Yes. So corporations, all right, so let's look at, so you got your sole proprietorship, you've got LLCs, and then you got corporations. So most people are using LLCs now if they're forming a business. If you're operating as a sole proprietorship, you need to get that bad boy into an LLC and protect yourself a little bit better. But what you're leaving is your membership interest in an LLC or your shares in a company. Okay, and those are considered personal property. And so those things pass by your will. So if you don't have where you leave that membership interest in that LLC to a particular person, then it's passing as part of your residuary estate and going to whomever you leave it to. But that is included as part of your property, even if you don't specifically map out where it's supposed to go.
Okay, thank you. I think she messed up the way for a sec, so I'll answer. There's another question by Jessica. I'm not sure if this one was asked again. She said she wasn't sure if you answered her specific question. If your parents are still alive, how do we take control of their property if they're both suffering from dementia?
Can we highlight that one for a second?
Okay, yep.
Because I think that's part of when we kind of talk about living our power of attorney and healthcare.
Okay, and living will. Okay, perfect. The next one was, my will is written in Illinois. I buy a home in North Carolina years later. Will the will cover the home, or will I need to redo the will in North Carolina?
It will cover the home. So if you're
cover that. Okay.
Yeah, I'm going to assume that you own that home individually and alone. So if your will says something along the lines of, I leave all my property, both real and personal to whomever, that North Carolina property is included in that. You don't have to specific.
Is that your advice to be general? And I'm just asking this question, piggybacking off of hers. Is your advice to be more general or more specific? Like instead of stating an address, just being general as far as?
Well, it depends. If we're leaving that new home in North Carolina to a particular person, then we're going to have a separate paragraph that says, I give, my property at, the address. And I typically will refer to the address and the deed book and page number. I'm just old school like that. So, either way I do, but we're going to make sure that property is clear, that property is being left to a particular person. If basically we're saying, okay, any property, anything I own, once we paid my bills, goes to my children equally, that is automatically included in that, under that umbrella.
Okay. I'll ask one more question now that she might pick up. In regards to property, do you recommend splitting everything equally between siblings and stating both need to sign to make decisions? It seems to me it may get messy if you have siblings that don't agree. And what do you do if you want to be fair, but know that there will be some issues? So I think it's like the second one is maybe like a second part, but again, just to summarize it, do you recommend splitting everything equally between siblings and stating that they both need to sign in order to make decisions?
So that's a very tricky question, I think. So if you're leaving everything to your siblings, that's part of what goes with it. I mean, what we're really talking about that they're going to continue to own together might be a business, and it might be real property. Okay, I'm sure y'all have heard of air property. Now, usually when we talk about heir property, we're talking about generational property that's been passed down, because people didn't have a will, and so we just go to children and just kind of gets messy from there. That can be an issue. That's where it gets tricky. Depending upon what the idea or what the plan is for the property, it could be a good idea to direct that the property be sold, and then the proceeds split equally, and then everybody will obviously walk away with their share, so we don't have to worry about that with the cash payout. But if we're going to own property for a period of time, that can get tricky if the siblings are not on the same page, because you could easily have one who wants to sell and one who doesn't, and then the one who does can force the sale, and the property basically goes through a very similar process as foreclosure. And so you literally are staying at the courthouse door auctioning off your property. So that's a tricky one. There's not a clear-cut answer. I think what we would talk about if you were sitting in front of me is, what's the goal here? What are the issues between the siblings? What are we trying to avoid? And then we take it from there. And that might lead us to a trust to hold that property for the benefit of the children. And then you have one person, the trustee, make the decision on when the property gets sold and things like that. It might be better to hold that property, which, I kind of discourage my clients from directing that property to be sold, because what if the market's tanked and you got a ton of equity in your house before the market tanks, and all of a sudden it tanks, and you're directing the property to be sold, and it, 2 years earlier or 3 years from now, it might be back up to 200% of its value again, of its current value. I mean, so I tend to kind of discourage that unless there's a reason for it. That way they can keep it, and if it makes sense to rent it or something else, or if one of them needs to live in it, they can make that decision together. But we'd really end up sitting down and really kind of talking about what the goal is there. I mean, that's gonna be a specific thing, I think.
Do you want to get into specifics about any of these? I know you said you focus on 4 key tools on your initial meetings.
Mm-hmm.
Do you want to talk about those 4 and then touch on the power of attorney a little bit more?
Yeah. So wait. So the other 3 documents, what we were talking about. So if no more questions about the wills, then what will kind of, and I kind of, let's go back to that question earlier. What was it? Taking control when suffering from dementia. There it is. So that's a good question. It's a good segue into the power of attorney and the healthcare power of attorney. So first, I'll say this. One thing I would do if you've got adult children, or if you're younger, is I still think everyone should have a power of attorney and a healthcare power of attorney in place. And if you've got children that are 18 to 22, 23, or they're in their mid-20s and not married yet, you need to encourage your kids to get through this as well. But you need to have it's a good idea to have a power of attorney in place, especially a healthcare power of attorney in place. The power of attorney, the durable, is basically, let's call it a financial power of attorney. And there you're giving someone else the authority to act on your behalf. I like to tell my older clients, because especially when they come in, they're like, the control thing. No, you're not giving them control of your property. You're just merely giving them the authority to act as your agent, okay, and to conduct business on your behalf. And so that can be important also with your young adults, because a lot of times you're the one dealing with the financial aid and some of those things if they're in college. And so that if we're really following the law with some of these entities that we deal with, that power of attorney really should be on record when you're handling that kind of business for them. The healthcare power of attorney is going to be the document that allows someone else to make those medical care decisions for you when you can't, okay? So if something has happened and you're unable to make a decision about your medical and healthcare, that healthcare power of attorney is where you have named that person that you want to be able to step in and make those decisions. We're all hearing stories, especially we hear them kind of as college starts every year. The news are kind of run these stories on issues that parents are having with being able to access their kids' medical records and make decisions for them when they're at college, because they're 18 now and all of a sudden they're at the house. mommy and daddy have been going to the pediatrician with them, sitting in the doctor's room with them, and all these things. And all of a sudden now they can't. And so that healthcare power of attorney can be important for the young adults. Now, and so even for my younger clients, we recommend that as part of the package and something that should be in your toolbox when it comes to this. Now, when we start talking about our older clients, which, any of us 70s babies are now having parents that are now hitting their 70s, and some even getting into their 80s. And so we are starting to see some of the dementia and just the slowing down in general. And so these two documents also are what we use for our older clients. And if you have a healthcare power of attorney in place and a durable power of attorney in place, and you start suffering, and say a parent starts suffering from dementia and they've got that in place, then what that does is we can kind of take those two documents and now be able to access bank accounts and basically help our parents and take care of their business. That's probably the easiest way to say it, but that, especially with that durable power of attorney. And with man, thank goodness for smartphones. My phone started ringing. Sorry. And so when we start suffering from dementia, that healthcare power of attorney can also become important, because now that's the document that's going to allow you to make sure that they're taken care of. The healthcare agent has the authority to make sure that mom or dad is in a place where they can be taken care of. And so you get that authority from that healthcare power of attorney to do those things. Now, between these two documents, the other thing it does is it allows us to avoid having to go to court and having that person declared incompetent and someone appointed as their guardian, okay? And so when we talk about guardianship and incompetency, in effect, what we are doing is stripping someone, and that's probably a harsh word, we're removing someone's ability to act with legal capacity, okay? And so people that are declared incompetent don't have the legal authority to enter contracts and to do things like that. Just like a minor technically cannot enter a contract. And so by having those two documents in place, and then a parent starts suffering from dementia and you feel like, hey, I have to take control from you because you're going to squander everything everything, all these years of hard work, and you've built all this money up, and now you're going to squander it and get cheated out of it. And there are people that will do that. We don't necessarily have to go to court to kind of here's where I'll say take control. We don't have to go to court in order to get that authority to do those things. You can step right in with the durable power of attorney, the healthcare power of attorney, and start to act and start to take care of those things. The only thing about the durable or the healthcare that I'll mention is that's not going to become effective until a treating physician has determined that the principal is not able to act and to make those decisions. And so it also does cover dementia as well. Okay, but those are two documents that we recommend. In fact, honestly, when I'm charging for a will, I don't even consider the powers of attorney as part of that package. I'm really charging you for drafting the will. And I'm like, look, you're in here, we're going to do this too. The fee is the fee. Whether you get these documents or not, you might as well get it because they're that important. They really are that important. I don't know if I've answered that question amply, but that is so important to have those in place. And then let's see here. And then
Sorry, so a quick question from someone I got earlier in an email. For instance, in the situation we have with COVID, you have a parent that goes to the hospital and you think they're just having breathing problems. They go, it's COVID, they're on the ventilator. What is the process of getting a power of attorney at that point? Because they're already in the hospital, you didn't plan for it.
So, well, I'll see if I can share. Let me see if I can. Do I have the ability to share? I'm gonna show you what it looks like. At least what my standard one looks like, if I can.
Let me see if I can give it to you.
Oh, I can't.
Get it for you.
And the reason why I was going to show it to you is because basically that healthcare power of attorney, I don't know if you go to a Duke, well, at least there's one in Wake Forest I go to, one of the Duke Medical Center facilities. In the lobby, they've got healthcare powers of attorney laying around the lobby for you to fill out and live in will. I don't know if you've seen it.
Okay.
That's part of the reason why I'm like, I don't really include it in my fee, because I mean, it's out there for you free. But I mentioned that because, you know, there's a good chance that that facility may have something like, may do like Duke does, where you could essentially go through those documents and read through it and have your, if your, you know, parent can sign it while they're in there, or they can even direct you to sign it, quite honestly. You can actually direct someone else to sign something for you in front of a notary, and a notary can notarize, quote unquote, your signature. And so those are all things, there are ways around those things. And I'll be honest with y'all, I don't know, y'all recording this is fine. I'm okay with my bar license. But if I know that the family is like there's 2 kids and everybody's on the same page, I don't worry too much about a durable power of attorney or healthcare power of attorney. I'll kind of walk through, here's where they need to sign, just because we know we need to get this taken care of so they can continue to conduct business. If I've got a situation where the family's not as close, and maybe I've only got 1 child in there and only 1 child's on the form, and some suspicion that there may be some issues, I'll do it differently. But for the most part, a lot of times when you get an emergency situation like that, you can step right in, and a form like that, we're not going to have too many issues with that. Get the signature on there, get it notarized, and typically we're going to be fine. And in this day of COVID, quite honestly, we can even notarize things. You know, we all had to pull out those books and really look at those rules again. But we can actually, even if I don't see you sign that document, if you tell me you signed it and that's your signature, I can notarize it. So meaning if that happens, we can still we just need to look at the situation and probably can figure something out.
Keith, you can share now if you'd like to.
Oh, let me see. I think I closed everything. There we go. Perfect. All right. So this is what a healthcare power of attorney looks like. And this is kind of our sample. So you'll see it, just a lot of blank spaces. But this is it. I mean, it's very simple. A lot of times what we'll do is, you know, usually it's the spouse, the primary, but oftentimes I'll have 2 children serving as co-agent, and we'll make it crystal clear that if one agent's not available, the other can step right in and make decisions. And even in this one, you'll see, even though it's kind of A, B, and C, if the primary is not available, the doctor can immediately talk to the secondary one or the third one without any issues. And so that's just very basic. It's not a whole bunch to it. Even the effect, you know, I mentioned earlier, it's the treating physician that would determine kind of when it's effective. If they determine that the person is not able to make their own healthcare decisions, this becomes effective. And that's who they're going to talk to. And I'm gonna kind of go to the second page here. And so, and it's a very broad set of powers. Kind of starts here, and it's everything. Your healthcare agent can make any kind of decision that you can make, your healthcare agent can make. I don't even bother going through this list anymore, because it's literally, they can literally stand in your shoes and make any kind of decision about your person that you can make, they can make during that time. Okay. So very, very broad. I mean, I'm talking hiring, firing doctors, authorizing surgery, all of those things. And another important thing I like to usually make sure I go through, and I'm not going to go through this quite like all of my clients, but this one right here, and I want to mention it because we don't talk about this very much, and that is what happens to your body after you die, and who makes those kinds of decisions about your remains. We don't think about that a lot sometimes. I think we will as we get older. A lot of my clients will say I've already paid for it and it's taken care of. But this document right here gives the healthcare agent the authority to determine what happens to your body. I always mention that here. But I will say this, I do have a case right now where the parents ashes are at the center of dispute between siblings. And this actually became very important in kind of quieting that particular issue down, is because the parents had given the son the authority as healthcare agent, which kind of pretty much wrapped up any argument that my client had. That's it. So that's very important as well. And then you see here, we got organ donation, where we address that in there, where you give your agent the authority to donate organs and that sort of thing. And that's pretty much it. And then right here, we talked about guardianship earlier. This paragraph here, all you're saying here is, if for some reason we find ourselves in court and we are trying to have someone appointed as guardian, this says that your healthcare agent's the first choice, your first choice to be your guardian. And this paragraph is important as well, because as people age and they do start to suffer from dementia, what I have seen is they become very distrustful of the people that are closest to them. And so I've seen it a couple times where the kids have had to take their parents to court to try to strip them of their ability to enter contracts and such, and to be able to kind of take control. And this can become very important, because this tells the clerk that when that person was lucid, this is what they want. They wanted that particular person to be their agent. So I can't see questions right now. Were there any questions about this one? And then I want to share the other document, another document with you, since I've got it here. Let's see. I can figure this out. And that's the last document we normally talk about, is the living will. And this stuff gets heavy. I'll tell you, when I do my conferences with my clients, when they come in to sign, we breeze right through. By the time we get to the will's done, easy, smooth sailing usually. But this one right here is one where we normally slow down a lot, because there's a lot of just conversation about it. And so in this document, what we're addressing is, if something has happened to you that's catastrophic and basically you are brain dead, it's probably the easiest way to describe it. The doctors are 99.99% sure that you are never going to open your eyes again. There's no brain activity and those kinds of things. This is the document that tells your doctors and your family what you want. And so what we do here is we have an option, and really it's pretty clear what it is. And so what we're doing here is you're telling your families that either that you want you order your healthcare providers to remove any lifelong measures, or you say it's okay to remove it at some point. All right, so that shall is, this is my instruction, this is what I want. Once you determine I'm in one of those three states above, then my instructions and orders are you are to remove lifelong measures and let me go on my own. The may is essentially saying it is okay to give it to you, but you don't want to be held on indefinitely, okay? For my late 40s or mid 40s and older, you guys probably remember that Florida case back in the early 90s, down in Florida, where the family was arguing over, I want to say it was Shriver, I may have my name wrong, but it was a lady that had suffered some catastrophic injuries. Her husband wanted to take her off lifelong measures. The parents did not, and she had nothing written. And so after that, this is when we saw everybody started really drafting these forms. All the states came up with them, and they have changed a little bit since then. But this is the result of that. I think I was in law school at the time, actually. But that's the big one here, is really that paragraph. And then we also get into, I'm sorry, I'm scrolling. Whether, if that happens, and once they remove lifelong measures, do you still want to see artificial hydration and nutrition? And so with those two, we end up usually kind of having some conversations between those two paragraphs there. But this is an important document as well. You hope you never have to pull this one out, but I think it's important to have it in place, because otherwise, everyone's guessing on what you wanted instead of you telling them what you wanted. So that's sort of the quick version of that, but just kind of let you see what's in it. And then here, it's probably a good paragraph as well, is, so the may kind of leaves a little bit of flexibility for your healthcare agent. I like to say they decide when lifelong measures are removed.
So,
They're not, go ahead.
all right, where are you in this document? What we see is the guardianship provision, number 7 and 8, and reliance of third parties on healthcare agent.
I'm sorry, wait. Are you there? I think I'm on a different one. Hang on a second, let me try it. Let me see something. How's that? That's a different document, isn't it?
It's nothing, actually. It's the black screen. Okay, now
No.
now we've
No.
got, this is it. This is
All right. I'm
living
sorry.
will. Is that what you wanted us to see, the living will? Or
Yeah, I'm sorry about that. So let me just kind of scroll back up. I thought y'all could see. All right, so that's that first part. That these are sort of the 3 triggering circumstances. I tend to believe that when you read through it, I tend to believe that if you're in one, you're in all 3. Because we are talking about we're basically talking about brain dead situations. A lot of times people say, well, I can just tell. I was like, well, no, if you can talk and communicate and your eyes open, we're not looking at this. We're not looking at this. And then you see the may and withhold the withdrawal and the shall withhold the withdrawal. Okay, and that's what I was talking about earlier with the shall. That's an absolute. Once they've determined you're in one of those 3 states, then you're saying, I want you to remove lifelong measures. Okay. And this is the part where I was, I think, on the nutrition and hydration. So you can also opt to continue to receive artificial hydration and artificial nutrition after lifelong measures have been removed. And so this is one of those ones where we have a lot of conversations right here. Just because there's a whole debate of, if we pull the plug and you're still giving me hydration and nutrition, but I'm dying, what are we telling the body? And so I haven't got a clear answer on that yet. I've had some medical professionals tell me, well, the body's trying to shut down. Here you are giving it nutrients and all those things. So, but we usually end up talking a lot about that. I don't know the right answer. I know what my preference is. I have bourbon penciled in on mine, at least next to my head. And that's all I need. Of course, you have the directive to be made as comfortable as possible here. And this is where we get into the healthcare agent part that I was just talking about. And so with the may, you really are kind of saying, you can give me lifelong measures, but I don't want to be on it indefinitely. And so here, if you say shall withhold the withdrawal, this is where we kind of either make it airtight or we leave a little bit of a crack in the door so that your healthcare agent can override your instructions. The first one is basically, they can't change it. Airtight, this is my last word, that's it. If they mark the second box, then the healthcare agent can come in and say, yeah, I know she didn't want lifelong measures, but you know what, give it to her anyway, I got a feeling. All right, so that you can see why that's so important, because it really does resolve issues like the rest of it. It's just kind of boilerplate stuff. But this document is extremely important. And I will go ahead and tell you that this is different from a do not resuscitation. The do not resuscitation, I think, is a form that you would get at your doctor's office, and you would, I think they give you a sign or something that you can put on your house at the front door, says do not resuscitate. That way, if EMS comes, they know what their instructions are. So it's a little bit different here on that. So just kind of note that. The other thing I'll mention that comes up a lot, kind of as a fifth form, if you will, is the HIPAA document. And I mentioned that one because I know a lot of people have young adult children, as I mentioned earlier. And so a lot of times people will also have or want their child to sign a release that allows them to talk directly with their doctor. And so that a lot of times there's a HIPAA form, but I'll tell you, typically when I have that conversation with my young adults, I say, look, you don't have to sign this. You can do it on an as needed basis, because otherwise it is giving your parents full access to your records and everything else, where you may want things to be a little bit private. And, 18 to 22, we're kind of getting into that age of, we want to keep more and more things away from our parents. And so I try to make sure they understand that. But that's the only other thing I would add in that, on addition to this living will. That's pretty much it. I'll turn it back over to stop sharing now.
So, Lasharo, are there any more questions in Facebook? The only other question we had here, Keith, is
Checking right now. Sorry.
find it. What information do you need for a non-family member if you want to include them in a will?
This name? Literally just putting a name in there. It depends on what we're leaving them, but typically my will say something along the lines of, my cousin so-and-so of Braxton, New York, or I just made that up, but that's how I do mine. I usually put a short description of the relationship, their name, and usually city and state that they live in.
Okay. And one more just came in. Even with the DNR in place, I've seen adult children override that in my career. Is that legal?
Say it one more time.
Can you override a DNR? If you have a DNR in place and the children override it, is that legal? Can they do that? Can they override a DNR?
Well, that's where the big question is, because again, the DNR is different. I haven't had a personal situation where I've seen a living will get overruled, if you will. If that's what we're talking about. Now that would be, to me, I'd have to see that document, because they may not have filled it out correctly. Or who knows? I've had clients come in and tell me some horror stories about, yeah, they had that in place, and yet still the doctor still did whatever. So I don't know, just because I haven't had enough information to see some of that. So I'd be curious to see what the bigger picture was and some more specifics on it. But it wouldn't surprise me that that's happened, though. I would not be surprised.
Okay. Lasharo, any questions from Facebook?
There are not.
Okay. Well, the last question, Keith, was for your contact information. So I do want to share that. And I also put it in the chat. So if you'll scroll up, and I can copy and paste this again and add it to the chat one more time. Just let me, 1 second. So there it is in the chat one more time. It's Attorney Keith Shackelford, and he's in Wake Forest with Warren Shackelford and Thomas Attorneys. Is that a good number, or you want to share a different number, Keith?
No, that is
That's it.
I'm old school. Call my landline. Do not text me. I still have a big yellow pad. I take notes, and I scan them. I am downtown Wake Forest. That's actually the wrong address, but that's fine. We are downtown Wake Forest. I've been at this firm now for almost 25 years, I think. I think I'm at 24. I lost track. And so I've been there. Good. It's 333. No, 343. Good gosh.
343. Still South White.
Yep.
Okay. Fixed it.
So, but yeah. And we're a general practice firm. I started out doing litigation primarily, and then things changed, and I got an opportunity to do this. I'll tell y'all, I can't see all the faces, but I think sometimes African Americans get stereotyped into litigation. So I was glad to do something else, just something I noticed in law school and afterwards. So estate planning is a lot less stressful, and you just kind of get people at a different stage. So it's very rewarding.
Well, thank you so very, very, very much. You did an awesome job. It's 8:15. He thought he would only be here for about 30, 35 minutes. and your questions, I think,
Thank you,
were really, really great. So that extended our day. So thank you again for joining. We hope to have more sessions next year. That is our plan under the financial literacy series. Lashara, did you want to add anything else?
Nope, I think that's it. Thank everyone again, like you said, for joining. This has been wonderful, these 4-part, and wishing everybody a happy holiday season.
Thank you.
Thank y'all for having me.
Thank you.
Appreciate it.
Night.
Good night.